Okay, picture this. Your big patent just issued. You've navigated the whole USPTO maze, maybe you're celebrating, and then you spot it.
Oh no, the dreaded typo.
Exactly. Maybe it's in a claim, maybe the description. And you think, how do we fix this? Is it easy, or is this going to be a major headache?
That's the million-dollar question, isn't it? And it's exactly what we're digging into today. We're looking at the MPP, the Manual of Patent Examining Procedure, specifically Chapter 1400 on correcting patents.
Right, this is part of our deep dive series into the MPP. Today's focus, Section 1481,
Right.
is all about certificates of correction or COCs, but specifically when the mistake is, well, yours, the applicant's fault.
Yep. And the key things we need to unpack are what counts as a minor mistake you can fix this way, and what's the absolute line you cannot cross without needing something much bigger, like a reissue.
So let's start with the basics. How can the USPTO even change a patent after it's already granted? Isn't it set in stone?
Well, not entirely. There's a specific legal mechanism. The authority comes from the law itself, 35 U.S.C. Section 255, and the rules, 37 CFR 1.323.
Okay, Section 255. What does it actually allow the director of the USPTO to do?
It gives the director power to issue a certificate of correction, but only for certain types of errors. The law says errors of a clerical or typographical nature or other mistakes of minor character.
Minor character. That sounds fuzzy.
It does, but patent law tries very hard to define it, and there are really strict conditions attached.
Like what? What hoops do you need to jump through?
Two main ones for Section 1481. First, the mistake has to have been made by the applicant, in good faith. No trying to sneak something in and fix it later.
Okay, good faith. Makes sense. What's the second?
The mistake cannot be the fault of the patent office itself. If the examiner made the error, or if it was a printing mistake by the USPTO, that's a different section. MPP 1480, that's usually simpler.
Got it. So 1481 is squarely on us, the applicants, when we mess up in good faith. Now, let's say we meet those conditions, we get the COC approved. What's the big win?
The win is huge. Once that certificate is issued, the patent is treated legally as if it had been originally issued in the corrected form.
Ah, so it's retroactive. Like a mistake never happened legally.
Exactly. It completely neutralizes the error from a legal standpoint, which is incredibly important if that patent ever ends up in court.
That sounds like a golden ticket. But something that powerful must have serious limits, right? What can a certificate of correction absolutely not do?
Right. There's a definite firewall here. Two big things COCs cannot do. First, they cannot introduce what's called new matter.
New matter. Always a red flag in patent law. What does that mean in this context?
It means the correction has to be something that was already supported by your original application when you filed it. You can't use a COC to add something new, some detail or concept that wasn't disclosed initially. It's only for clarifying what was already there.
Okay, no sneaking in improvements. What's the second major restriction?
The correction can't involve changes that would actually require a formal reexamination of the patent. Basically, if the change raises a new question about whether the invention was patentable in the first place based on the original disclosure, then a COC is not the right tool.
That makes sense. You can't bypass scrutiny. This really brings us to the heart of it, doesn't it? The difference between a simple typo fix and something major.
Precisely. This is the bright line rule we mentioned. The absolute core distinction boils down to whether the mistake affects the scope of the claims.
Claim scope.
Yeah.
Okay. Give us an example of something clearly on the fixable with a COC side.
Sure. A really common example is a clear typo in the specification, the written description part. Let's say you misspelled a common chemical term like alkane became alkene, but everywhere else it's correct and the context makes it obvious what you meant. That generally doesn't change the legal scope of the claims.
Okay, simple spec typo, probably okay. But what if the typo is in the claim language itself? Say a claim limit reads less than 5%, but all the data, all the examples, the whole prosecution history points to more than 5%. The intent seems obvious.
Now you've hit the wall. Even if the intent seems crystal clear from the file, if correcting that mistake would change the scope of the claim, especially if it broadens the claim, it's almost certainly not considered a minor error under the statute.
But why? If everyone can see what was meant, why be so rigid?
It comes down to public notice. Patents are public documents. Competitors, the public, they rely on the exact wording of the issued claims to know what's protected and what's not so they can design around it or decide whether to license.
Right. If you could easily broaden your claims after the patent issues using just a COC, it would create huge uncertainty for everyone else.
Exactly. That kind of change, modifying the actual legal boundaries of your monopoly, requires a much more formal public process. That's what a reissue application is for.
Okay, this distinction is critical. Is there case law that really hammers this point home?
Absolutely. There are a couple of key cases everyone should know. First, there's Arnott. This case basically laid out the two-part test the Patent Office uses.
Which is?
One, the error must be clerical, typographical, or minor. And two, the correction must not introduce new matter or require reexamination. You have to satisfy both conditions.
Okay, both parts. And what about the claim broadening issue specifically?
That's where Superior Fireplace Co. v. Majestic Products Co. comes in. The Federal Circuit Court made it unmistakably clear in that case. A mistake that results in broadening the scope of a claim simply cannot qualify as a minor error fixable by a certificate of correction under Section 255.
Wow. So it doesn't matter how obvious the mistake seems. If the fix broadens the claim, COC is off the table, period.
Pretty much. The administrative convenience of a COC just vanishes the moment claim scope is implicated, especially broadening.
So claim scope is the legal firewall.
Yeah.
If you need to change scope, you have to gear up for a reissue proceeding with all that entails public notice, potential intervening rights for competitors.
The whole 9 yards. You can't use the C2C shortcut for that. And this leads us neatly into another area. Things COCs can't touch, even if they look kind of like clerical errors.
Ah, the procedural traps. What kinds of mistakes fall into this category?
A really big one is errors related to benefit claims or foreign priority claims. Where you claim the benefit of an earlier filed application or a foreign application.
Like getting the filing date or the application number wrong? That sounds pretty clerical.
It sounds clerical, but fixing it isn't just correcting a number. Those claims affect the patent's effective filing date, which is legally crucial. Fixing them often requires the USPTO to decide if you were diligent, if the mistake was unintentional.
I see. It requires more than just looking at the text. It needs evidence and a legal determination.
Exactly. So those usually need a separate petition under different rules, like 37 CFR 1.78E or 1.55E. You typically have to submit declarations, provide evidence. A simple COC review isn't set up for that.
Okay, so benefit and priority claims are out for COCs. What else?
Issues around identity are generally excluded too. Things like fixing inventorship adding or removing an inventor or changing the listed assigned name.
Why inventorship?
Because inventorship goes to the fundamental validity and ownership of the patent. Changing it requires very specific legal steps, usually sworn statements from the inventors explaining the situation, proving diligence, again, way beyond a simple correction certificate.
So the pattern seems to be, if fixing the error requires the USPTO to look beyond the face of the documents, gather external evidence, or make a complex legal judgment, then a COC under 1481 is probably not the right path.
You've got it. If the fix is fundamental, like inventorship or priority dates, or if it touches claim scope, you need a dedicated, more formal process.
This brings us to the standard they actually use when deciding if a COC is appropriate. You mentioned it has to be obvious.
Yes, the standard is that the error must be manifest on the face of the record.
Manifest on the face of the record. What does manifest mean here, practically speaking?
It means the error has to be clear, obvious, undeniable, just from looking at the patent file itself. The application is filed, the amendments, the examiner's actions, the issued patent. You shouldn't need any outside or extrinsic evidence to prove the error exists and what the correction should be.
Okay, so back to my misspelled alkane example. If the word alkane appears correctly spelled 50 times in the application file, and just once it's misspelled alkane in the issued patent spec.
This is a pretty strong case for the error being manifest. The internal evidence within the file itself points directly to the mistake and the correct version. No need to bring in outside proof.
But what if it's more ambiguous? Let's say a term is used inconsistently. Maybe the spec mostly uses term X, but the claim uses term Y, and you want the COC to change the claim to X.
Now it gets tricky. If you need to submit, say, a declaration from the inventor swearing they always meant to use X and Y was just a slip-up in the claim, well, that declaration is outside evidence.
Ah, extrinsic evidence.
Right. The moment you need that external proof just to establish that an error occurred or what the correction should be, you're likely outside the scope of a COC. The error isn't manifest anymore. That kind of situation, especially involving claim language, points towards reissue where that evidence can be properly considered.
Because the Patent Office wants the correction itself to be solid, based only on the clear record, so it's less likely to be challenged later in court.
Precisely. They're protecting the integrity of the patent grant and the correction process. And just a practical note, remember, even though it's the applicant's mistake, there are fees involved in requesting a certificate of correction. It's not free.
Right, good point. So let's pull this all together. What's the big strategic takeaway for an applicant or attorney who finds that gut-wrenching error after the patent issues?
The main takeaway is that MPP Section 1481 provides a really valuable tool, the certificate of correction, but its use is very specific and limited. It's meant for truly minor, obvious, clerical type errors that absolutely do not change the patent's scope.
It's like a scalpel, not a saw.
Exactly. The critical strategic decision is assessing the nature of the error. Does it only correct a clear slip-up that's obvious from the file? Or does it, even slightly, broaden or change the meaning of the claims, or require outside proof?
And if it does touch scope or need outside proof?
Then you really need to resist the temptation of the quicker, seemingly simpler COC path. The risk is just too high. If a court later finds the COC was improperly used, especially to broaden claims, it could potentially invalidate your corrected claims or even the whole patent.
So the safer, albeit maybe more involved and costly, route in those cases is the formal reissue proceeding.
Generally, yes. For anything affecting claim scope or requiring external evidence, reissue is designed to handle that complexity properly and publicly, preserving the patent's enforceability. Use the COC only when the error is truly undeniably minor and manifest from the record itself.
Don't risk the patent for the sake of a shortcut.
That's the bottom line. Choose the correction mechanism very carefully based on the nature of the error, not just convenience.
Excellent advice. Well, that covers our deep dive into MPP Section 1481, Certificates of Correction for Applicants' Mistakes.
And before we wrap up, we definitely want to give a special thank you to Mike Shepard. He's the creative director who organized this entire MPEP audio series.
Absolutely. Thanks, Mike. And finally, everyone, please remember the disclaimer. This summary was put together using AI tools like ChatGPT and NotebookLM. It might have errors or omissions. It's for general educational info only.
That's right. It is definitely not legal advice and no substitute for formal instruction. For authoritative guidance, always consult the official MPEP itself, talk to a qualified instructor, or get advice from a registered patent practitioner.
Thanks for joining us for this deep dive.